All right, everyone. SCOTUS is ignoring its own decision again. A very, very strange case here. Rahimi versus U.S. versus Rahimi. It countermands their decision 8-1. Bruin almost in its entirety, and it's kind of funny how only Clarence Thomas seems to sort of get it. His dissenting statement actually sort of lays it out in brief. The idea under the Bruin decision was that if you were going to have some sort of rule with regards to the exercising of the Second Amendment, that is the right to keep and bear arms, not just guns but other weapons as well, there's a differentiation there that I notice is not addressed in this decision, that it has to have a historical precedent. You have to have sort of a tradition, a history of that kind of law being implemented, going back to, the old days when the founders were alive. And so you can say, for example, that a musket would not have been afforded to a criminal maniac. That much is true. I would point out that that criminal maniac would have been simply locked up, and they would have at least been in a cell in their house or something like that. They wouldn't have been allowed to freely roam the streets. The founders would have countenanced such a thing. They would have thought it perfectly acceptable to deprive arms from someone who cannot be counted on as a member of the militia. For example, somebody who is exceptionally violent, so a mass murderer, or someone who's incarcerated at the time. You can't have a musket in the jail cell. Or somebody who is a lunatic. A lunatic would have been locked up, though. They would have been held ward by their family or by their community on the funny farm, or they would have been, again, in a cell of some sort. That sort of technically anti-arms, not just anti-gun, proposal would have been perfectly fine to them. They would have frowned upon the concept, though, that a person who is simply alleged to have committed acts of domestic violence could be deprived of their right to keep and bear arms barring a trial. If you think that someone is a menace, so if somebody has a domestic violence order against them, they should be subject to criminal proceedings. It shouldn't even be a civil matter. They either broke the law or they didn't break the law. If they broke the law, they should be imprisoned. And of course, they can't have a gun or a knife or anything like that when they're in prison. If they haven't, then they should be free to exercise their rights. So the Rahimi decision is very strange because they upheld, again, the concept that a court can arbitrarily strip somebody of their right to bear arms for 2 years simply because of what is effectively a civil claim leading to a restraining order. So a judge can deprive a person upon topical complaint by any plaintiff of their ability to participate in militia activities simply on a whim, simply because it's the court's opinion that they broke the law. Well, if they broke the law, then put them in jail. If a person's imprisoned, that's a different story entirely. If a person is beating their wife, or kicking the shit out of their kids, or they're threatening their neighbors, or any of these other things that can lead to a restraining order, they should be in prison. They should not be free to roam the streets. If you're saying that they're too violent to own a gun, why is it that they can still own other methodologies of death, by the way? If they can't be trusted with a gun, how can they be trusted with a car? You can run that person over quite easily. You can do a lot of damage with a truck or something like that. Why should they be able to own fertilizer? They could make a bomb. Why should you be able to own gasoline? You could start making Molotov cocktail, like kerosene, something like that. Why should they be able to literally mail order a flamethrower? Well, that's not a gun now, is it? They're allowed to own weapons. They can have all the knives in their kitchen. They can have a sword. They can have a machete. They can have a baseball bat. They can have all sorts of things that can cause bodily damage to another person. They're trusted with that. That's perfectly fine. It's outside of the court's MO to care if they suddenly buy a pair of broadswords or something like that. But a gun? No, that's unique. It's unique, legally speaking, how firearms are treated as opposed to arms in general. And that's something that I've noticed as well. The founders would have said, if someone can't be trusted with their musket, they can't be trusted with the bayonet either. And you're certainly not giving them a barrel with blasting powder or something like that. Those things, though, these individuals can still freely purchase. They can freely possess. They don't run afoul of any state or federal law in so doing. But for some reason, they can't own the pew-pew or the ammo for the pew-pew. What's the difference? They can own a black powder weapon. Those aren't covered. Those aren't generally going to be covered under a restraining order. They can own those. You can mail order them. You know, you get your heavy iron or something. Okay, that's still deadly. You know, something that fires a heavy ball, an old 45 caliber ball or something like that, at a short distance is still going to be quite lethal. There's a confusion in the law, therefore, on the pragmatic front. And then there's the legal front itself. It countermands Bruin. This kind of decision doesn't make any sense whatsoever, and it makes me fear their eventual decision with regards to some of the state anti-gunnery, like with regards to which state is it, Maryland or something, that banned all semi-automatic weapons. Well, a semi-automatic weapon, that's basically the same as saying a weapon manufactured in the last 100 years, generally. Is that decision going to be like an 8-1 in favor of anti-gunnery despite Bruin? Because I'm wondering, how can Roberts sign off on such a thing? How can, by the way, all three Trump appointees signing on to it as well. Clarence Thomas was the only one who had common sense on this particular decision. So the other so-called conservative justices, yet again, showing themselves not necessarily to be conservative. I understand the pragmatic argument, which is, well, we don't want domestic abusers owning guns. Okay. Again, though, they can buy a flamethrower. They can buy a machete. So you're not really protecting actual victims. You're just depriving people who have been alleged to have done wrong things of their rights, and you don't even have a criminal proceeding against them. They're not an actual criminal. They're not in jail or anything like that. You realize a restraining order is effectively a civil matter. I can petition the court for a restraining order for anyone that I want. Now, they might laugh it out of court if there's literally no basis. But and typically if men file for a restraining order, they're denied anyway. There is also a great deal of sexism within the court system in many states with regards to this. Your girlfriend has to take a baseball bat and start beating up your car in broad daylight in front of 20 witnesses in order to get a restraining order against her. All she has to do is turn on the tear. I hate to tell you, dudes out there, and I'm no MGTOW or anything like that, but this is true. All she has to do is turn on the Amber Heard tears in front of a judge and say he slapped me, and you can get a restraining order against you. So be careful who you date. Make sure that they're sane, etc. This is a very bizarre decision because it countermands Bruin entirely. The same incarnation of the court not long ago authored Bruin. They said there's going to be a litmus test with regards to gun laws, that you have to have a historical tradition. Yes, it would have been fine to the founders to take the musket away from somebody who was beating up his wife in the middle of the street. Her relatives all know that she's being beaten, something like that. You would have been considered a menace. But they wouldn't have simply taken your musket. They would have taken your sword. They would have taken your pitchfork away, and then they would have locked you up. Or they would have done a little bit of vigilante justice and put you in your place. I noticed that that's illegal these days too, unfortunately. Maybe we need a little bit more of that and a little bit less of the lawfare bullshit. This is a shameful decision because it literally countermands a pre-existing statement by the Supreme Court itself that many of the people that signed on to this decision voted in favor of. Clarence Thomas is the only one that had consistency on this decision. That's about all. Peace out.